When licensing commercial software and IP rights are involved, two additional and related topics are 1. Ownership of derivative works as between the publisher or developer and the government. 2. Ownership of IP issues between an employee and his or her employer. As a general rule, the publisher owns the IP rights to the products it licenses when no changes are made to that product. This is shown on the far left-hand side of the chart. On the opposite side of the spectrum, customers often hire development firms to create custom software to meet their unique needs. In that case, the customer owns the IP rights to the solution that is developed as a work-for-hire, as represented on the far right side of the chart. Issues arise when there is a hybrid or combined solution that involves COTS software and customized or derived code, as represented in the middle, dark gray area of the chart. In this case, the contract language must be carefully drafted to allocate ownership rights appropriately. In some cases, the publisher may end up owning the IP rights to the derivative work and grant the customer a worldwide perpetual royalty-free license to use the derivative work. In other cases, especially where the customer does not want its competition to gain access to the derivative work and the customer has paid significant amounts of money for these customizations, the customer would seek to exclusively own the IP rights to the derivative work. As for IP ownership between employees and employers, this is usually governed by a document signed as a condition of employment, granting all right, title, and interest to such IP over to the employer. In the government, this is governed by statute. The Federal Acquisition Regulation, known as the FAR, is the set of rules that govern all U.S. federal government acquisitions and is codified in Title 48 of the U.S. Code of Federal Regulations. The clauses in FAR 52.227 address intellectual property in general, and clauses 52.227-14 through 52.227-21 specifically address data rights. FAR 52.227-14 is commonly referenced for COTS software procurements. The Defense Federal Acquisition Regulation Supplement, known as the DFARS, provides DoD implementation and supplementation of the FAR. DFARS Part 227 addresses general intellectual property issues, while 227.70, 227.71, and 227.72 address data rights in more detail. Part 227.72 is commonly referenced for COTS software procurements. Thank you for viewing this tutorial. Please visit the DoD ESI website for more information and other videos in this series.